Good afternoon. Please be seated. We're on to our final panel, and this is going to be a very stimulating panel, after which we have a cocktail reception. We don't want to delay either. Okay, please be seated. Okay, I'm Stu Kaplan, co-chair of the Professional Education Committee and helped to plan this conference. It's my honor to introduce your moderator for this last panel of 5 FERC chairs. We have Judge Brenner, a senior administrative law judge who was deputy chief judge and an ALJ from 1994 until he assumed a position as a commissioner on the Maryland Public Utilities Commission, where he sat from 07 through 15, returning to FERC after that. He has chaired several committees that were relevant to activities within the PJM states, is a personal model that I hold in high esteem, and I know that to the extent that I fall short but still try to emulate him, it will make me a better attorney and human being. With that, I turn it over to our double honor, Judge Brenner.
Uh-oh. Well, you know, I have my hand on my wallet after that intro. It reminds me of Mark Twain's line that the difference between a eulogy and a testimonial is that a testimonial, at least one person believes it. But I want to thank, you know, those of you in the audience who helped me get the senior title, because some of you have given me gray hair over the years. But before I introduce our esteemed group of former FERC chairs, I want to thank Steve Shapiro, who couldn't be here. Steve conceived the idea for the panel, scoped it out, and got it into shape to get it on the program. So I should say also that if there's anything you don't like about it, well, blame Steve. But so in order of their terms, and also as Stu mentioned this morning, we invited Betsy Mola, who fit the criteria of a former chair who's no longer commissioner, but she had a schedule conflict with an out-of-the-country schedule, so could not join us, unfortunately. So on my immediate left, this is in order of their terms, is Jim Hecker. Jim is senior counsel. You got that senior title also with the gray hair.
And the gray hair.
Yes. Is senior counsel at Hush Blackwell here in D.C., and he's principal of Hecker Energy Law and Policy. I hope you paid attention to the name because it has a great acronym. You figure it out. His clients include WIRES, a nonprofit trade association that promotes transmission investment. Next is Patrick Wood III. Pat is principal of Wood 3 Resources, also nicely named. And he is board chairman of Dynergy, lead director of Sun Power, and director of utility contractor Quanta Services. Next we have Joseph Kelleher. Joe is executive vice president, federal regulatory affairs for Next Era Energy, Inc. Next Era is the parent of Florida Power and Light. It's a Fortune 200 company and is included in the S&P 100 with about 15,000 employees in 30 states and Canada. It's also headquartered in the very nice locale of Juno Beach, Florida. If you ever want to visit, just give Joe a holler. John Wellinghoff. John is CEO and founder of Grid Policy, Inc., which works in support of distributed energy resources. John refers to some of his work as leadership at the face of disruptive energy systems with traditional utility structures. So hopefully along the way today, we'll find out about the disruptions that John is causing, if not working with. Norman Bay. Norman is a partner with Wilkie Farr and Gallagher here in DC, where he heads their energy regulatory and enforcement group. And he also practices in the corporate and financial services department. Many of you know Norman was director of enforcement at FERC before he became a commissioner and chair. So I think of his current position as having a back to the future aspect to it for Norman. So if you see a flux capacitor zooming around, that could be Norman. With that, each former chair going to make some brief opening remarks, giving you some context and their perspective on occurrences during their term. Our intent is to leave a lot of time for questions from the audience. This would be your opportunity to ask things you mused about over the years, about just what were they thinking. And with that, I'll turn it over to Jim.
Thank you, Judge. It's great to be here. Thanks to the Energy Bar, and I know we're all happy to be regarded as smarter probably than we all are. But on my way in here, and I see a lot of fresh faces out there. Somebody said, "Didn't you used to be Jim Hecker?" And I'm just here to confirm that. Yeah, I'm speaking sort of for the Cretaceous period of FERC regulation, going back to, well, I started at the commission as a staff attorney in 1979. That'll tell you something. I spent a lot of time as assistant general counsel, as an assistant to two commissioners, working on implementing the NGPA and PURPA, and helping write Order 436. All that is pretty hoary legend, but when I came back to the commission in 1993, it was on the cusp, I think, of some pretty important changes that we're still working through today. It's an interesting period because it was pre a lot of the technologies, both in the industry and in communications that we have now. It was pre a very refined concept of energy markets. It was a period when there was less, at least in my view, less conflict between state and federal jurisdiction, both in terms of personal relations, but also, if you recall the article that the late Bob Nordhaus wrote a couple of years ago, the line between federal and state jurisdictions tended to get very fuzzy due to a lot of new technologies that I think I'm sure that John's going to talk about. Well, I became chairman in 1997. Thank you, Bill Clinton. And it was a period when we were moving fairly rapidly from being cost of service regulators to helping to oversee more emerging markets for energy, especially on the gas side. Gas side had gone through the 436, 636 process. And although we passed Order 637 to kind of refine things, gas markets were working pretty well by the time I left office. Order 2000 is an important landmark, certainly in the period I was there. It established RTOs and began to put some institutional meat on the bones of open access. And I think it was a major step forward, although, of course, it still only applies to part of the country, although a very substantial part of the country. I mentioned Order 637 already. I do think that pipeline restructuring was a big success. And frankly, it happened between 1978 and 1992. And although it continues to be refined and argued about, frankly, the gas restructuring, not deregulation, which everybody used to call it, was a pretty big success by the end of the last century. Electric restructuring is another can of worms, and we began that with PURPA in 1977. We're still working at it, and it'll be interesting to see what the new commission does to advance the ball on that. One of the things I did at FERC was FERC First, a little institutional process to restructure the agency, make it a little more efficient. And out of that process came the Projects Office, ADR, the Office of Administrative Litigation, and a lot of the electronic filing and case tracking capabilities that we have, and it's been really advanced substantially since then. But what didn't we have? Well, we didn't have civil penalty authority that was worth much. However, we're in the middle of the controversies that gave rise to parts of the Energy Policy Act dealing with market manipulation. You probably remember a little thing called the Western electricity crisis, which California was the epicenter of. That was really quite a stressful and regrettable time, but it shows the amount of seeking and experimenting that we, at the federal level, and especially at the state level, were doing at that point about how to design markets, how to make them work without punishing consumers. We had not really ramped up our grasp of energy markets, and I'm very happy to see what has transpired since then in that regard. Reliability was a kind of informal arrangement stemming from the blackout in the 60s, and it wasn't until the 2005 Act again that we had an ERO in the form of NERC to set mandatory standards. And FERC had not gotten to be so visible in the media because of its work in energy infrastructure as it has become recently. I guess I'm thankful for that, but building infrastructure to serve these emerging markets has become more necessary. At the same time, it's become more problematic and controversial. And of course, I was chairman at a time when, as important as we believed renewable energy and distributed generation, things like that were going to become, they weren't yet terribly competitive, weren't having much of a market impact. Well, how much things have changed since then? Well, I think you're going to hear from my successor here, Mr. Wood, some really good news about what happened next.
So I drank, similar to Jim, I had the opportunity to work at FERC before I got to come back and lead it. And I drank the competitive markets Kool-Aid back at, way back in 91 to 93, when as legal counsel to Commissioner Jerry Langdon at the all-day FERC, I got to be Langdon's point guy on Order 636, which, as Jim pointed out, was the closing chapter of the gas restructuring era and was fascinating. So 2 years later, the newly elected governor of Texas asked me to lead the Public Utility Commission there with the characteristically straightforward charge of, Pat, get us to a market. So in both telecom and electric power, over the next 6 years, I got to do that. And through a really splendid collaborative process, which I did take from there to here with me. Some of it didn't translate too well, but back then in Austin, the process between the governor, the bipartisan legislature, the utilities, the customers, the competitors, and the think tank people, everybody really converged to Texas, and the utility industry converted from regulated industry to a wildly competitive retail and wholesale marketplace. And now, about 20 years later, I suppose, 19 years later, with few fundamental tweaks, this law is working well to keep the prices down. The prices are much lower, bills are much lower. A lot of investment, interestingly, a tremendous amount in the renewable sector, despite the lack of subsidies there, and a lot of business innovation. So I'm pretty proud of that. But so needless to say, when my boss got a promotion, well, I guess you call that a promotion. Well, when I fly into this city, I still have that. Love it, but. So, and having played offense for 6 years, I was reluctant to leave. But when the California energy crisis continued, 2000 continued to be front page news in 2001, my old boss asked me to come clean up the mess. So by the time I was confirmed, then Chairman Kurt Hebert had devised the bones of a remedy, a good one, and Nora Brownell and I were the fourth and fifth votes for that in early June of 2001. when I joined the commission. And so that intervention in the market, though, however, was light years away from what I dreamed I would be doing 6 months earlier as the finishing touches were put onto the competitive Texas market. But the price cap, which was known then as market price mitigation, and I was very clear about that with then Vice President Dick Cheney, who led that, who hated the price caps. I do think that was necessary. It was the right thing to do. Cooled down the market, gave us time to retool, but it was difficult. I mean, philosophically for me, but it was also difficult for the commission. And although you left me plenty of dockets, including that one to close out, Hecker did leave a great FERC staff structure in place. The FERC First model was excellent. I only made 2 changes to it in the 4 years there. The first one was for the Office of Market Oversight and Investigation, which right away we needed to bring in some more market expertise, people who had actually worked in the markets at high levels and could understand the details of energy marketplace. And then secondly, after the first the North American blackout of 2003, the reliability division, we put that in place as well to really start that informal at the time, and then Joe took the ball from there with good legislation. But to build the bridges between us and the industry on this important half of what we do, which is to keep the lights on, with NERC, with the utilities, and that place also the Canadians as well because of their binational role in that institution. I guess on the kind of second half of our question, the philosophy that I brought to the FERC was on my chalkboard for 10 years. So those of you who've been in my office know it's making markets work. It's the triangle, the 3-legged stool, robust infrastructure, balanced market rules, and vigilant oversight. All 3 of those things are needed to really make the world better for customers. And better for customers coming from growing up as a son of a small businessman, that was my perspective. You could pretty much always see that the orders from the Wood era always had a sentence in there usually that said, this order benefits customers because, or ... fill in the blank. That perspective was always important to me, and I wanted our staff to always think about what we were doing and its implication on end-use customers, whether they be wholesale or retail, depending on the topic there. And having been a regulator before I was a deregulator, I knew that regulation was really just a poor substitute for what customers could get. Sometimes it would actually be a sham. So I do think that markets as well, without infrastructure, without balanced market rules, with poor oversight, were just as bad for customers. So FERC had to be in that great place, which is in the middle. And the issues that I promoted in either rulemakings or in orders as they presented themselves were kind of in 4 big baskets. One, reducing cost and removing barriers to entry, particularly for new market entrants. That means standardizing everything I could see. Standardizing barriers to entry, standardizing issues that related to investors, to retailers, passing on to customers charges, keep that as low as we can, standard market design, standard generation interconnect in the early years for large generators, in my last year for smaller generators, and of course continuing support for GSB, which then became NASB. Second basket, transparency items, the old year, Order 2001, Order 2004, get market information out there to allow the market to help us regulate. Collaboration with other sovereigns, state PUCs were, as coming from that world, very important to me, so we wanted to have them be important collaborators in the oversight of the RTOs. Canada through the blackout issues, Native Americans through our new tribal liaison, which we introduced then. And then final basket of issues that I always looked to try to emphasize was the allocation of risk, because I saw how successful it worked in the natural gas industry, taking it from the back of the captive customer and putting it out where people who could actually manage that risk better in the marketplace. And so that has been really the support, long support for independent power producers, for independent marketers, for people that are not regulated and don't have the benefit of a rate base to support their decisions, but have to justify it into a marketplace. I think the rate policy that was codified in '99 that the chairman spoke about today is an outflow from that era where we moved pipelines to at risk. And we continued at that period the cross-subsidy hostility that I continue to chase on as a villain today when I go after crony subsidies that are still existent in our market today. So happy but tired by 2005. I handed the gavel to Mr. Kelleher.
Thank you, Pat. So, Joe, we're moving towards EPAC in 2005,
Sure.
I think.
Just a thumbnail on my background before FERC. I don't have the same FERC pedigree as Pat and Jim. My exposure to FERC was the public document room in 1983. I was a paralegal when I got out of college. And I'd go to the public document room and I would, beg them. It was like the soup Nazi line from Seinfeld. Can I please have the Merwin Dam decision? And very few people here probably know what the Merwin Dam decision was. But if you were super polite, you'd get a photocopy, a pretty bad photocopy of a decision. So I started probably at the real bottom of FERC, the begging end in the document room. And then I was a lobbyist. I worked on the Hill for a bunch. But I always admired independent agencies, and I always thought they were more disposed towards merits-based decision making. And then later on, when I was a committee counsel, we started working on electricity legislation, and I started paying a lot more attention to FERC. And I was impressed how it was, to me, the least partisan of the independent agencies and the most merits-based in decision making. So I admired the agency, and then I had a chance to actually join as a commissioner. And to me, it really helped being a commissioner for a period of time before becoming chairman. And it really helped to see Pat as my model. I call Pat my chairman. But when I became chairman, Energy Policy Act was in conference. And people forget there were anti-FERC provisions in that bill in conference, and there were some really important grants of authority. And to me, it was very important to drop the bad stuff and keep the positive grants of authority. Because I had a Hill background, I was sort of in a good position to do that. I had worked for the House Energy and Commerce Committee. The chairman I worked for, Joe Barton, was chairman of the Conference Committee. I'd worked a lot with Senate Energy Committee. So they knew me, and I had some level of rapport and trust with them. And I also had come from the administration, so I could work with the White House political and legislative staff. So we were very successful in dropping the hostile or negative provisions and keeping all the positive grants of authority. Then the question came to, well, what are you going to do with this authority? How are you going to implement it? And I thought we needed someone at FERC who that was their full-time job, and it needed to be someone who commanded the respect of the whole agency and staff. And to me, that was Cindy Marlette. So she was in charge of EPAC implementation. And in a very deliberate way, an orderly way, we proposed and finalized a series of rules. And only one was vacated by the court, the Fifth Circuit. Bob Solomon probably remembers this, the Texas Pipeline Association case. And that was a case where it was a transparency provision that was really poorly worded. FERC did the best it could with pretty ambiguous legislative language. And I have to say the Fifth Circuit was right in the end. But we otherwise had a really good record implementing EPAC 05. I just want to highlight two of those actions because they're still relevant and still resonate. One is the enforcement program, right? FERC was given very substantial enforcement powers, anti-manipulation authority and civil penalty authority. And even though FERC had some enforcement authorities before EPAC, Jim referenced them, they were pretty modest. They were actually oddly more robust in the hydro licensing area than in the electricity area. But FERC was given $1 million a day penalty authority and with a lot of discretion to define what a violation was. So the question was, one thing I don't think people fully understand is the conditions that led to the birth of that authority and the grants of that authority. And it was the California Western Power Crisis. So when we were establishing the program and implementing the rules, we knew why Congress had given that power to the agency. FERC had been very unfairly pilloried for not exercising non-existent penalty and manipulation authority. Now, once it was given to FERC, it seemed that we actually just couldn't put it on the shelf. We had to exercise the authority. And I felt particularly kind of pregnant on that matter because I had written an Energy Law Journal article, and I had used a Winston Churchill quote, "Give us the tools and we'll finish the job." And I thought, well, okay, if Congress has given us the tools, I can't just put it on a shelf. That would be pretty bad. Now, okay, if you wanted to establish a pretty strong program and you understand the DNA, kind of the origin of the program, namely a reaction to the California Western Power Crisis, then how do you do it? How do you set up a program that's really dramatic change from what FERC had done in the past? And what we decided to do was survey other agencies that had both criminal and civil enforcement authority. We looked at Justice Department, we looked at the independent agencies that had substantial civil penalty authority. John Moot led that effort. It was a really scholarly survey looking at the procedures and policies of the other agencies, and we, in the end, decided to model the program on the SEC program, considering it to be the gold standard of the non-criminal enforcement programs. And I thought John did a terrific job. And we moved very quickly. We proposed the anti-manipulation proposed rule was issued 2 months after enactment of EPAC, and it was finalized 3 months later. So it went from 5 months from enactment of a law to adoption of a final rule. And it was an instant final rule because we were still dealing with the reaction of the price fly up from Hurricanes Katrina and Rita. So we didn't have the usual 30 or 60 days or federal. Now the moniker of the program inside and outside was firm but fair enforcement. But I have to concede that, given the origins of the program, it probably felt more firm than fair for a period of time, and the balance was perhaps tilted in favor of firm. But I think that's understandable if you, again, remember why the authority was given to FERC in the first place and what led Congress to act. A couple comments on the reliability program. We spent a lot of time on how to implement the reliability provisions. And at the time, I had a lot of doubts about NERC's capacity to discharge the responsibilities it was given under the Act. And I thought it was necessary for FERC to adopt a larger role until NERC expanded its capacity. Almost like a big brother throws his arm around a little brother until he gets some more muscle. And we had a lot of internal deliberations about if that was going to be the agency's posture, what does that mean in practice? And the role manifested itself in different ways. There was a critical review of the initial standards that NERC proposed. FERC really vigorously exercised its directive authority, issuing, I think in the end, a few hundred directives, actually. At one point, it was 600 directives. I'm not sure what the current number is now. FERC shelved some of the reliability standards proposed by NERC. It issued an ERO certification rule that provided for a 3-year license, not a one-time permanent license. And that larger role surprised many. The head of one regional council described it as turning a pyramid upside down. But that role was always intended to be interim until NERC was ready to fulfill its responsibilities. And I think NERC is a much more capable institution than it was in 2005. And with that, I think I'll end my comments, and I look forward to the Q&A after we hear from my colleagues. Thank you.
Thanks, Joe.
John?
And thanks to Larry for the introduction, and I want to thank EBA for having me here today. Well, my colleagues that you've heard from so far had some level of experience with FERC prior to joining FERC, or in the case of Jim, actually working at FERC in the staff level. I had none. To give you a little of my background, I had 30 years of experience prior to becoming a commissioner at FERC with rate-based cost of service regulation in the states, primarily Nevada and a number of the western states, but I really had no concept or appreciation for wholesale markets or their impacts, effects, and operations. So when I came to FERC, I was really sort of agnostic, and I stayed somewhat agnostic for a period of time, but under the tutelage of my chairman, Chairman Kelleher, and all of the people that Joe channeled before him, and all the people that have established the foundation, including Betsy Moeller, who's not here today, I think, did drink the Kool-Aid and became a real advocate for markets, really understood that they did have a power for consumers, and they did have the power to help consumers control their bills and their costs if we did use Pat's principles and ensure that they're properly enforced and properly structured and properly overseen. So that was really, as I launched into the chairmanship in 2009 with again, the good background of a number of years under Joe, was my perspective. And I took that perspective, and then from the consumer protection background I was actually Nevada's first consumer advocate and did that for 7 years. And also from my background in sort of technology and efficiency, combined those two and really tried to ensure that the markets were open and fair and transparent and workable for these new resources that I saw coming on. And some of the new resources that I saw coming on, I'd bring people into the office and we'd sit down and talk about flywheel systems that were becoming available to provide regulation service. We talk about new advanced wind systems and solar distributed generation systems. And I wanted to ensure that those systems, in fact, could effectively compete in markets. So from that, we developed a series of rules. One was Order 745, which I'm pretty proud of. 755, which is not quite as well known a rule, but I think equally important. 719, 764. I think they were all important in ensuring that all resources can efficiently and effectively compete in these markets. And then we took it one step further with respect to competition and efficiency, and in Order 1000, the transmission planning order, we tried to ensure that there was some level of competition in the planning and selection of transmission. In fact, I just got through writing a couple papers on the issue, and it's interesting to see how you can issue an order in 2010 or 2011 when Order 1000 came out, and you're still working on perfecting the implementation of it. So it's an ongoing process. But you know, I'm very encouraged by what the current FERC is doing and how they're, I think, continuing with the building blocks. And it's really interesting just to listen to my colleagues today and understand how much there is a matter of the building blocks that are in the progression, I think in a very positive progression, have moved us towards more and more efficiency in markets and better operation and working in those markets. And I think, you know, our current chair and the current commission in their order with storage, their workshop they did on distributed energy resources recently, the order that they just issued on rehearing on in the Kentucky case, all these things I think are helping all these resources effectively compete in markets. I look forward to working with the current commissioners in that regard. And I think with that, I'll turn it over to Norman.
Well, good afternoon, everybody. It's great to see so many friends and former colleagues here, and it's great to be on the same stage as Jim, Pat, Joe, and John. I feel very, very lucky to have succeeded them as chairman of FERC. You always stand on the shoulders of those who precede you, and there's some pretty big shoulders on the stage today. I have to tell you that I always felt this obligation to live up to their legacy and to be a good steward of this amazing agency that I had been given the task to lead. And as I listen to their comments today, I'm struck by a number of recurring themes. One is the nonpartisan nature of the work that we've been doing, the ability of Republicans and Democrats alike to come together to get things done to further the public interest. I would bet that if anyone were to listen to the comments of anyone on the stage and didn't know what political party they belonged to, they would have no idea whether that person was a Republican or a Democrat. And how great is that? Another theme is that we each had challenges, but we managed to not only meet those challenges, but to overcome those challenges. And that speaks a lot to FERC's strength as an institution, its reliability, and indeed perhaps even its resilience. Then there's a way in which, that wasn't intended to be a joke, but I'm glad someone found it amusing.
It's a hot button word.
A third recurring theme is the way in which there has been broad agreement on fundamental policies, and that has helped make consensus possible. One has been the value of competition and markets, as well as making sure that the markets, once you've created them, have integrity. Another has been recognizing the value of infrastructure and the way in which infrastructure can make markets more competitive, more reliable, and more efficient. A third recurring policy theme has been reliability. After the 2003 blackout and EPAC 2005, that clearly was a very important charter for FERC. Another recurring theme, the way in which the Commission has worked to enable innovation, to identify change when it occurs, and then to help industry adapt to that change. And then I would say another theme, and I'm sure everyone on the stage feels this way, the way in which we each have a deep respect, if not a love, for the agency, its mission, and its people. And so I think you can see these themes running throughout the work of the Commission over the past 20 years. And for myself, I clearly built on the work of my predecessors. I issued a proposed rulemaking on energy storage and DER. I worked on improving price formation with my colleagues in the RTO-ISO markets. I worked on improving gas-electric coordination. And I'm particularly pleased to say that because of the great hiring decisions that all of my predecessors made, that in the 2017 Federal Employee Viewpoint Survey, FERC was rated the top mid-sized agency in government. And how great is that? You know, there's that saying that FERC speaks through its orders, or the Commission speaks through its orders, but I would even go a step beyond that, and I would say that the Commission speaks through the work of its staff and then its orders, because you have staff at FERC who are incredibly hardworking, dedicated, and talented. When I think about the work that we collectively have done over the past 20 years, I would say that we have helped pave the way for electrification. Why does this matter? Because in 2016, more emissions actually came from the transportation space than from the power industry. The last time that happened was in the 1970s. And last year, carbon emissions, were down 25% from 2005 levels, which means that even though the Clean Power Plan has been stayed, we're 80% of the way to meeting its target of a 32% reduction by 2030. Right? And to a large extent, I think this is because of the power of markets. And so I should also add that electrification then allows for the ongoing decarbonization of the power industry to be leveraged throughout the rest of the economy. And in this process, there's a role for gas because gas resources can provide flexibility that complements renewable resources. So if I had any suggestion for FERC, and I'm sure that they don't need my suggestion, it would be to continue to work on laying this groundwork for the electrification that I think will be coming in the next few years, and certainly throughout the 2020s.
Okay. Thank you. So Norman, let me start with you. Jim alluded to the bright line, or maybe not so bright line, and Bob Nordhaus's paper on it is really worth reading, between state and federal jurisdiction. And John mentioned the recent commission decisions, I think exactly 3 weeks ago, if I remember the date, 2 decisions involving Kentucky and PJM regarding the participation of energy efficient resources mandated by the state, and it talked about the retail and wholesale markets. So Norman, is anything new there? What's significant, if anything, in those decisions from a jurisdiction point of view, and also from an EER, energy efficient resources point of view?
Yes, the decision that Larry's referring to is advanced energy economy, and it's a really interesting order because the commission held that states did not have the authority to veto the participation of energy efficiency resources in the wholesale markets. And that denial of the rehearing order builds upon the EPSA decision. And so one of the things that's very interesting to see is the number of issues related to this blurry line between state federal jurisdiction. Of course, there was the Supreme Court trilogy involving One Oak, EPSA, and Hughes. but now we have an advanced energy economy, though it's a FERC order, not a Supreme Court decision. But you can see these federalism issues cropping up in other areas as well. For example, the right of first refusal at state ROFRs. That issue is now being litigated in a district court in Minnesota. You can see federalism issues with respect to gas pipeline siting in Section 401 of the Clean Water Act. You can see federalism issues in the capacity markets and the treatment of ZECs, and whether or not ZECs should be preempted, as some have argued, or should not be preempted, as 2 district courts have held. So I mean, to me, this is very interesting to see. What I don't know is whether, as a historical matter, we're seeing more federalism challenges than in the past, and if so, what might be causing it? I think Jim suggested it could be developments in technology, right? In the past, you had central generating stations, and you didn't have these distributed resources. You didn't have demand response. There was less of an emphasis on energy efficiency resources. So perhaps that's part of the explanation, but I'd be interested to get the perspectives of my colleagues on the panel today.
Well, you pointed to Jim. I could jump to him, and then I'd like to hear from John, because I know his work focuses in part on energy efficient resources. But let's go to Jim.
Well, I'd be remiss if I didn't mention the electric transmission area, which is always a difficult kind of infrastructure to permit. We focus a lot in the commission, because of the way the Natural Gas Act is written, is focused on how to better implement Section 7 of the Gas Act. But what has happened, and a lot of us have talked about, how electricity markets have become more regional, become even national, but they've become more dynamic, and the Federal Power Act and its division of responsibility between the states and the federal government hasn't changed at all. So we have this interesting situation where we're trying to square a circle. We're trying to implement vibrant markets based on very seamless infrastructure based on a statute that had a completely different vision of how the industry was organized. And that is a problem that I think will be addressed sooner or later, but it certainly is a barrier right now to further development of the grid, and one that is leading to 10 to 15-year delays in the development of needed infrastructure compared to 3 years for a natural gas pipeline, and that's highly problematic. The solution may only be legislative, however.
John, do you want to jump in? And also, what do you think was significant with respect to EERs in those 2 commission cases, the paired cases?
Sure. Thanks, Larry. And I agree with Jim that we are seeing, expansion of markets and extended regionalization. You're seeing California's got a bill up right now, AB 813, to change the governance of the CAISO so that it really can expand more robustly throughout the western United States. But at the same time that's happening, what you're seeing, I think, is exactly what Norman said, but even, on steroids, you're seeing the distributed resource technologies just explode, and you're seeing the enabling technologies underneath them, which are really the communication and control technologies, get less and less expensive and more affordable and more available to consumers. My son, who's a truly computer geek, he graduated from RIT in Rochester, was cataloging through the house the other day, our house the other day. We have 52 addressable devices in the house.
Damn.
I'm going, where are they, Jim? What have you done? Are you bugging every room? And, is there bugs in the bathroom? What's going on here? But, I mean, and so, all those technologies can address different appliances, different controls, different things within just our house that ultimately could be, products that could go up into the wholesale market. I mean, you know, and it's all available. It's all available very inexpensively. So that's why this explosion is happening. And as to the, you know, the Kentucky case, especially, I think it's extremely important with respect to their clarification there in EPSA of the jurisdiction of FERC with respect to the issue of these behind-the-meter resources and their ability, enabling the ability of consumers to, if they desire to, individually or in aggregate through aggregators, participate with those resources in wholesale markets. I think it's important that we enable them to do so because they are exploding and expanding, and they can be utilized to help be part of that increasing the efficiency of the overall grid.
And can also do what we didn't have the ability to do in 02, 03 when we were looking at a standard market approach, which is to have that demand play in the market and to really discipline the market in a way where you wouldn't have to have the FERC enforcement division go out and persecute market power or have very prescriptive rules that mitigate prices in certain markets and certain times of day, because you have such fluid ability of customers to respond in real time and to do it with you know, not just real-time pricing and regulatory constructs like that, but the type of things that John has talked about. So I think it's fulfillment of the dream because we found the silver bullet. We just have to make sure that bullet can actually hit the target.
Let me segue a little bit. Two U.S. district courts last summer applied the 2016 Supreme Court cases that we've alluded to. Most directly, the district court decisions applied the Hughes case and also the EPSA Supreme Court case. I should throw in a full disclosure here. I was actually a named party in the Hughes case in my official capacity in Maryland, but happily, given the way the case turned out, I was relegated to et al. And Hughes got all the play. Those two district court cases have been appealed to their respective circuit courts, but I don't want to focus on the jurisdiction, although of course you're free to address that. But I was wondering if you had opinions on whether zero emissions credits or ZECs, I'm not sure we have the best acronyms in our industry, but the ZECs, are they a good idea? Jim, start with you.
Are they a good idea? Well, I mean, you know, I think they could be very good for the environment. I think the jurisdictional question is troublesome. They're not a good idea if they can't be made to work, and they're, I guess both the cases you allude to are on appeal.
Yes, to two different circuits. I think, well, one is the Second Circuit. I forget the Illinois Circuit. I think maybe the Sixth Circuit, if I remember right. Maybe the Seventh, I'm not sure.
Zero emission credits in New York and Illinois are, frankly, another way of trying to keep nuclear plants that may not be economic online. And, you know, there's a debate about that. I think Pat and some of our other colleagues have, including John and Joe, have weighed in on whether those kind of out-of-market solutions are a good idea in other contexts and for other technologies. And generally, they're not. I mean, they're not something that the Commission would approve of. But in the ZEC cases, the way it's structured doesn't necessarily tread on FERC jurisdiction. So I'm not sure how this is going to come out.
Any other views?
Well, you asked the question of, are they a good idea? No, they're crony capitalism by just a new name with a new letter. And, you know, when a utility...
Tell us what you really think, Dad.
I participated as an amicus with a very prominent Democrat, Peter Bradford, who has a great nuclear pedigree in the New York case, but we were bounced out. But I do think that FERC has got to take, it's not its role to advocate, but it's got to take an informational role to let these state legislatures know and maybe, you know, writhe in pain from the truth being told by an objective agency, but to be told what damage these kind of things do to the operation of the competitive markets that we worked for a quarter century to set up. I mean, that's exactly what they are, and the resilience thing looks like a continuation of the same crony game, and I just think it's poisonous to markets.
Well, I'm glad I didn't ask you to tell us what you really think about it. I think if you come up with good alliteration, that's half the battle in your argument. Anybody else want to jump in before I segue to pipelines?
Joe, do you have anything?
I mean, I agree with Pat's view, and I do think it's clever jurisdictionally, but that doesn't mean FERC can't mitigate the effects of the ZEC transactions. And I did think that in New York, there was a decent challenge at the state level, too, whether the New York Commission actually had the authority to approve the program. And I don't think that's run its course yet.
Norman?
So I'm going to be the contrarian on the panel here, and I think I'll make it much more fun for you than if we were all agreeing on everything all the time. I do think that there is a policy argument in favor of ZECs, and this is the argument. The problem here is that there's an unpriced negative externality, and that negative externality is carbon emissions. And I think everyone on this panel would agree that the first best solution, if you care about carbon emissions, is to put a price in carbon and then harness the power of markets. That clearly has not happened, although at least one RTO is looking into putting a price on carbon. The second best solution, and I would say second by a long ways compared to the first best solution, is to provide financial incentives to resources that do not produce the negative externality. And that's essentially what states are trying to do. So the argument would be that running the market now without taking into account the negative externality results in an inefficient market outcome, and that states are actually trying to correct that imbalance by providing support to resources that don't produce the negative externality. So I think that would be the argument, and some have certainly made that with respect to ZECs.
And that would be fine. I think if all if all resources of now and in the future that could qualify for that could participate, as opposed to like in the New York case, which is very egregious, that named plants were in there, and one was excluded, which was the same zero emitting resource. So I think that is a good argument. It should be like a kind of a rec program on steroids, a much larger part of the market. I don't like it, but it's not offensive for the raise that the other two are.
Okay. All right. I'm just going to have a couple more questions, so I want the audience to think of your questions. This is going to be your chance. Segueing to pipelines, FERC will be considering possible changes to the 1999 pipeline policy. Chairman McIntyre alluded to it at lunch today in his talk. So, Joe, what issues would you address if you were still in charge?
Okay.
You could be
Well,
king for 5 minutes.
After the review was announced, I actually read the certificate policy statement, which I hadn't read in a while. And I was actually impressed at how current it felt. I mean, it really, if you look at the goals that are laid out in the policy statement, it's promote competitive markets, protect captive shippers, avoid unnecessary environmental, community, landowner impacts, while serving increased demand for natural gas. Are those still the goals?
It was brilliant.
Well, it really was.
So I was going
99.
Jim was chair at the time, of course.
But even the issues the Commission's grappling with, the Commission grappled with in the policy statement. You know, the possibility of overbuilding, avoiding unnecessary environmental impact, avoiding unneeded exercise of eminent domain, whether FERC should look behind precedent agreements, whether FERC should apply a different standard to affiliate or non-affiliate. Those were all the Commission grappled with in 1999. So I think the Commission, it felt very current and modern in the sense of what the Commission was grappling with. I personally think the certificate policy statement is very sound. I think the improvement, if I were a judge reading the certificate policy statement, I'd be nodding a lot. I especially like the balancing the benefits against the adverse impacts. I would think a court would naturally think that, yeah, sure, that's the right way these decisions should be made. I think the bigger area of improvement is actually in the certificate orders themselves, because balancing is not very transparent in a typical certificate order. The need is transparent in a certificate order, but not the benefits of a project. And a lot of applicants, including NextEra, we identify the benefits of a proposed project in our application, but frequently those benefits are not explained or identified in the certificate order themselves. And so I would think that's one big change, that the certificate order should be more transparent on, in the balancing, what are the benefits of the project? And then what are the adverse impacts? I think that would strengthen them on judicial review. And I just think it looks more like an APA kind of decision when you do that sort of balancing. Because that balancing isn't transparent, the certificate orders seem to swing on need and how much of the capacity is reflected in precedent agreements. If balancing was more front and center in the reasoning of the certificate order, I think the need becomes more of a secondary consideration. And therefore, like issues of should affiliate precedent agreement be treated differently than a non-affiliate precedent agreement is a lesser concern. I frankly don't understand some of the arguments on affiliate precedent agreements. They seem to they seem to reflect a point of view that somehow affiliate pipelines can arrange for affiliate precedent agreements where nobody bears any risk in a completely unnecessary pipeline that has no value and no market need somehow can be profitable to both the pipeline and the affiliate that has no possible use for the gas. And I think that's a bizarre perspective, because that affiliate is either a marketer or producer, or they're completely at risk, and the pipeline will find itself with a bankrupt affiliate shipper, if you look at a hypothetical where the affiliate takes 100% of the capacity, or it's a utility or a gas LDC. It's an end user that either the state has approved that precedent agreement, and I would think shouldn't necessarily second guess the state, or they're at risk. They have to prove the prudence before a state commission. So I don't really see the scenario and the threat of sham transactions, because they seem wildly absurd in the non-end user scenario. And then they're also subject to state review either in advance or after the fact. But one of the interesting questions is, well, if you're doing this balancing, what are you balancing? And in the policy statement, it says, well, the benefits on one side for sure, and it doesn't explain all the possible benefits. But on the negatives, the impacts, it emphasizes landowner and community impacts. It's a little ambiguous as to is environment part of that, is environment also on that end of the scale? To me, that raises, you have to really look at the NAACP case, right, the 1976 case, and say, is protection of the environment within the ambit of the Natural Gas Act? And racial discrimination was found not to be within the ambit of the Power Act in the Supreme Court decision. Is protecting the environment within the ambit of the Gas Act? The word environment only appears in cross-references to NEPA. So I think there's actually a fair question that even if the Commission wanted to include protecting the environment in the balancing, can it under NAACP? And if they can, it seems what they're balancing is the unmitigated environmental impact. And my last point is, one thing I'm glad the Commission is looking at is the length of the process itself. The FERC certificate process is taking much, much longer than it used to. It used to be pre-filing was a 6 to 8 month exercise. Now it can be a 14-month exercise. It used to be you could get a certificate 9 to 11 months after you applied for it. Now it's sometimes 25 months. So the process is taking vastly longer than it used to. And I'm glad the Commission's at least asking questions like, can we improve the process?
Okay. Jim, do you want to jump in?
Well, electric transmission developers would kill for a timetable like that. But I think you're absolutely right. I know that there are a lot of things that have changed in the gas production and delivery environment since that 1999 statement. I think every once in a while it's good to go back and take a fresh look. We were very aware of the possibilities for unnecessary projects based on precedent agreements that were fundamentally phony. We had one pipeline, major pipeline in the east. We kept saying, where are the contracts? Where are the contracts? And finally, all of a sudden, an affiliate mysteriously appeared with one sole purpose, to hold the contracts. And we said, so, I mean, that's something the Commission's been aware of for a long time. On the transparency issue, although this doesn't really help your time argument, these cases aren't set for hearing. You know, the Commission's meat and potatoes in terms of getting at the facts and developing a public record used to be to set things for hearing. And certificate cases are not set for hearing. And I think there might be some threshold, or it should be some threshold in the policy statement, or that evaluation of the 99 statement, that would trigger a hearing in some of these cases, because the Commission just doesn't do the kind of investigation it used to.
All right. I actually have a question I'm going to hold for the end so we can go to the audience now. None of us can see from here. Well, I should speak for myself. I can't see from here. So I think some folks have microphones and they'll have to see. Raise your hand, jump up and down. This is your shot.
No questions.
Yeah, ex-chairmen are not very scary. So.
Yeah,
Or has been, yeah.
Great.
if we can't answer it, we'll make it up.
Great. I mean, as Jim said, didn't you used to be somebody? You know?
Here we go.
Here we go. Gary, that guy
Gary.
from Baltimore.
Oh, a movie question.
Chairman Bay mentioned the litigation in Minnesota challenging the state legislature's enactment of a right of first refusal for transmission siting. The Wellinghoff administration in Order 1000 had said the federal ROFR was unjust and unreasonable, but it was honoring the state ROFRs, which you could read as meaning that there was no objection to the state ROFRs as interfering with federal jurisdiction, but yet the allegation in the court is that it's an unconstitutional violation of the Dormant Commerce Clause. So I was wondering if any of the chairmen here have a view as to the allegations being raised that were not raised in the proposed rulemaking that led to Order 1000, that the Commission should be eliminating all of the ROFRs. Apparently, if it was a matter of federal preemption and constitutionality, the Commission could have itself taken this action that's now being sought in the courts, in the federal court in Minnesota.
Well, let me start and just speak to the policy and not the law on it, in that I haven't looked at the law on this in a long, probably since Order 1000, since we did Order 1000. But I do think fairly strongly from the policy perspective that we need to open up the competition in the transmission area. And I think, you know, like, Jim and his group have been advocating for, you know, speedier transmission development. We're not going to get it unless we somehow can open this up to more competitive developers providing for that transmission, number one. And number two, I think the other part of it is there not only there's going to be a lack of transmission development if we don't foster that competition, but secondly, we're also going to stamp down innovation, and there are many innovative technologies now that are coming into the transmission space. A number of firms that I'm very familiar with that can do some amazing things with technology that actually are substitutes for transmission, that need to have the opportunity to go in and ultimately compete for providing these transmission services against the incumbents. And if we don't do that, you know, the whole system will, you know, it's going to even be worse for what Jim's advocating for. So that's my policy take on it, and I'll let somebody else go on the law, on the legal issue.
I can take a crack at this, Gary. So when I was on the commission, I wrote a concurrence that noted that in approving Order 1000 issue, that the commission was not resolving what I viewed to be a dormant commerce clause claim regarding the was not resolving his dormant commerce clause claim. And so I've read the Minnesota District Court's, or the DOJ's brief with some interest. I don't think the court has ruled on it yet. I think DOJ filed a brief arguing that, in fact, there was a dormant commerce clause violation. For those of you who aren't dormant commerce clause geeks, what it forbids is a state from discriminating against out-of-state commerce. And facial discrimination is very, very hard to justify under the Dormant Commerce Clause. Other kinds of discrimination, perhaps you could justify under something known as the Pike balancing test. But it's that kind of analysis that DOJ goes through in its brief in that particular proceeding. It'll be interesting to see what the court decides to do with it. Your question was, well, could FERC basically proactively find that under the Federal Power Act that state ROFRs should be disallowed? And I think that's a really interesting question given the scope of FERC's authority under the FPA and its charter to ensure just and reasonable rates and to prevent undue preferences and discrimination. I think that there's probably a very reasonable argument there as well that FERC could act if it wanted to under its FPA authority.
I think
Good afternoon. For most of our respective careers, the agency, the FERC, has been a model of nonpartisanship or bipartisanship, and I know that you all on the stage are really very proud of that. Last year, the involvement of the DOE in proposing a NOPR suggested the potential for the politicization of the agency, that for many was somewhat worrying, for others somewhat encouraging, as it held the potential for the involvement of a cabinet-level official in FERC-related matters. And of course, the FERC turned that back and launched a different initiative. Do any of you have advice for the Secretary of Energy with respect to the level and nature of engagement that you all would think be appropriate looking ahead?
I think we provided that when we provided comments. Norman was excluded because of his post-employment restrictions, but the four of us plus four others, I think, were gentle but nice, but firm. And FERC is there as an independent agency. Yes, it's under the budget authority of the Secretary. And Governor Perry honored that, by the way. He went through the process. It was done by the law, a seldom used law, but one that's nonetheless fair. And I think the Commission handled it very professionally, as they have handled less political issues in the past. So I think the process actually proved the resilience of the FERC, which it may be political pressures, not gas pipeline or others that are the resiliency we need to worry about most of all. But they passed the test, so I give them kudos.
Yeah, I'd say that the Secretary is the head of a very powerful research and development organization. I mean, the DOE has the national labs, a lot of great people over at its headquarters, and it could be a great partner in advancing national energy policy. I think that we can hope, and that this little adventure was kind of a sidebar to satisfy some constituent out there. It reflects FERC's independence, but the Commission could certainly use profitably better data about a lot of things that are happening in the energy industry, a lot more R&D on new technologies, and how they might be used in future energy markets. I welcome Norman's comments about coming electrification and how the grid is possibly going to respond to EVs and more electric heating and a whole bunch of new technologies that are going to place untold stress on the grid unless it's modernized using a lot of the technologies that John talks about. DOE has to be a prime mover in helping to develop that vision, and if the Secretary will focus on that, he'll do well.
Other questions?
Good afternoon, gentlemen. The commission sets cases for hearings in front of administrative law judges. Have you found over the years that the types of cases that the commission sends to these hearings has changed, and if so, how?
We should maybe, in the interest of full disclosure, point out that it's Judge McBarnett asking the question.
I don't have a sense of that.
Yeah, we sent a lot of the California energy markets crisis era cases to hearing, and that was probably, I know that the traditional one, I mean, my first FERC experience as a baby lawyer was A&R rate case 89-161, so that was those kind of things. The rate cases obviously have always been there, less so on the electric side. Those tend to be small cases that just get solved, but the big California cases required a fact-based hearing. We were having mobile Sierra challenges to contracts. We were having issues regarding market manipulation and tariff interpretation. So the FERC tried to shape the legal issues in the case by the referring order, but we, at the end of the day, had to have a fact record. I mean, I'm listening to what Jim was saying a minute ago about the certificate cases. Those don't have to be long cases that add months to the process. If the commission says, do it fast, I'd tell Judge Wagner, I'm not telling you what to say, but I'm telling you when I want you to say it. And he'd get it back to me in 4 months, 6 months. He'd send it to Carmen, it'd get done in 2. She's fun, golly. It's a phenomenal resource that I felt when I got there was underused. And I think it probably has shifted over time. I don't know how it worked in the later years, but when the kitchen was hot, they were the best allies to have. Sometimes they told me what I didn't want to hear, but they got us a record, and it moved its way through the courts with a lot of support.
Yeah, I don't know about the types of cases that are set for hearing over the years. Almost everything that comes before the FERC has some genuine issue of material fact. Some dispute, and the commission does have to be selective. It has spent an awful lot of its resources in very big policy initiatives that are absolutely necessary, but litigation, and the Office of Administrative Litigation is where the rubber meets the road at FERC, and it's currently very well led, and I think that they could handle more cases. I think that would add, as Joe said, more transparency to a lot of processes.
You may know that almost all the cases that the commission currently sets for hearing, they set for settlement attempts first, and in some cases that's worked.
What about ADR?
Right, that's what I'm talking about. Yeah. The settlement judge cases ADR. Of course, parties are free to do ADR outside too. But actually, a lot of cases have settled, but I don't want to toot my own horn, which some people referred to earlier. We have time for, if people will indulge us, a couple of more questions, and then I saved one question for the end. Any more? I can't see.
There's one in the back.
No?
Straight back.
Yeah.
While he's going there, we always used to call that little back room by the hearings the orthopedic surgeon room, where all the broken arms would get healed.
Hi, I'm James Downing of Powermarks today. It seems like a lot of the friction between states and FERCs is coming in the capacity markets. I know Chairman Bay sees maybe a different future, but do any of you see a major change with that? Do you see, could we go to energy-only markets, or so just get rid of the capacity markets, or at some point?
Well, as one who comes from the energy-only market of Texas, it works. We'll see this summer will be a real good test. So ask me this question at the end of September. But, I do think you can design a market that is tight and compensatory at the same time, but that's not how we chose to go in the East. In fact, I think that disparity is why that never showed up in standard market design, because I personally wasn't convinced you had to have a capacity market. When you have a wide open retail market, you effectively have the retail customers and the retailers forming their own voluntary capacity payments in the rate they pay. Now that customer can bail a little bit easier than he can bail in PJM from paying a capacity payment, but I don't think a capacity payment's required. as a chairman of a former generator, I sure liked them, but it was easier to get money that way than to have to work in the energy market. But the reforms that are made to address the MOPR and related issues of state subsidies have worked or could work intellectually in the capacity markets. I think where they fail is to address energy market revenues, because those subsidized resources are generating out of stack round the clock because they got their money paid for, so they're distorting the energy market every 5 minutes. Whereas in the capacity market, you can probably do some patching there that I think is a not a great workaround, but it's not going to be deleterious long term unless you get a whole lot of plants done that way. But I do think the energy market has a very different issue when you are having the subsidies instilled by state policies.
And I would just add to that on the capacity markets. Again, when I started learning about markets, I started embracing capacity markets as well when I was at FERC as chair, and thought that we could, in essence, come up with the ideal structure, whether it may start in PJM or someplace else. Although I'll tell you, as I get older and think about this more, don't tell him this, but Bill Hogan may be right. Ultimately, I think capacity markets are very difficult to design correctly and functionally. I'm currently working in Alberta. The ISO there in Alberta and the government there has committed to put a capacity market in what now is an energy-only market, and I'm working for a client there trying to help them help the ISO come up with a design that will work for everybody, and we're close to pulling our hair out, just trying to figure out how we can structure one that doesn't cause my client to go bankrupt and doesn't hurt consumers and raise prices more than necessary. It's not a trivial exercise to try to get all the moving parts right in the capacity market to make it work. So I'm now, I guess, agnostic about capacity markets. So.
Hold on. Anyone else want to jump in? No? All right. So I'd like to ask true confessions here. Would any of you like to confess to a mistake or at least some impulsive act that you'd want to take back?
Other than eating at the Sunrise Cafe too many times?
Hey, I had something there this morning. It sure was nice to be back.
Joe?
I will confess my most impulsive, and I think maybe my only impulsive act at FERC. And,
I've been waiting to hear this for weeks.
Yeah. Sorry. In part because I'm among friends, and I can trust your confidence, and also because it's been more than 5 years since I took the act. But I really liked the FERC Hydro program. So I had a meeting with FERC Hydro staff, and they said the vineyards in the Russian River, where there had been a drought in California. It was like second or third year of the drought. And the vineyards in California were petitioning, asking FERC, me as chairman, to authorize the release of water from hydro projects in the Russian River. And at first, my first thought was, I really like Russian River red wine. I didn't express that, though. I thought that. That was the thought bubble. But then my question to staff was, well, what legal authority do I have to do that? Which, I'm proud that was my first question. And the response was, it's highly questionable, which is FERC staff speak for non-existent. And I thought about it for about 10 seconds, and I said, release the water. And it felt very Christ-like, right? I knew it was the closest I would get to being holy, authorizing water, not directly turning water into wine, but authorizing water to be turned into wine. And I thought, look, if I go down, I'll get a Wine Spectator cover or something like that. So I'd get some compensation. And then the next year we had another meeting. The drought still continued one more year. We had a very short meeting where they said the wineries were asking for more release of water, and again, I said, release the water again. So if I'm in a wine store and I'm undecided, I can't choose, and I see a Russian River Zinfandel or something, I just smile and grab the Russian River wine.
It could still be the right year.
It could be. It could
Gotta
be.
be one of your years,
yeah, right. So.
Anybody else want to confess?
God, how do you follow that?
Can't top that one, no.
No regrets? See, I confess an impulsive act.
Mine was summer of, we announced the standard market design, which was going to solve all the issues that happened in California and then some. In the summer of 2002, went to Wall Street and rang the bell with staff and Nora and I don't remember who else, I think Massey might have come too. Anyway, we went there, saw Mamma Mia, all this stuff. So that next month I was off. Not Mamma Mia, whatever was out back then. Well, maybe it was Mamma Mia.
Yeah, it might have been.
Oh, two? Golly, I'm getting old. All right. So we went home. I went home to Texas with my children and wife for that next few weeks to just take like we did in FERC, take the August off, and kind of just didn't do a whole lot of work. And one of the things I did not do was return Alan Franklin, who was then CEO of Southern, phone call. And I think if I could have talked them out of getting so, I don't know, maybe I'm overselling my persuasive skills. Maybe that was never meant to be. But if I could have talked them out of being so intransigent against standard market design, and if I had been maybe on down the road a little bit more willing to accept imperfections in their RTO applications under Order 2000, they came in with, there was RTO South was more of the SCANA, but it was C-Trans. It was Entergy, Southern, some others in the South. Accepting that, it could have avoided, what I call the carnage that's happened down there with non-competitive generation investment that's sitting on top of customers for the next generation throughout the South, where I've got a lot of friends. But, if we'd have just done a little bit, imperfect though it would have been in wholesale markets in the South, and probably analogous in the Southwest as well with West Connect. I'd have been a little bit more flexible, but I was pretty rigid on making sure you meet the criteria of Order 2000, and neither one of those had sufficiently independent governance. So that might be one I would have taken mulligan.
Maybe if you had convinced Texas to lead the way as part of the RTO with all the other southern states.
Well, that's what I did for 4 years. They didn't want to follow. I tried to bring the Texas model to Washington, but I think the president doing that was enough for everybody. I didn't think they needed it from me.
Norman?
So my regret is not as profound as Pat's, which dealt with standard market design, or as profound as Joe's, which, released the water. Have people in this room been to the FERC holiday party? Anyone here? So if you've been to one of those parties, you know that one of the most important decisions a FERC commissioner can make is what kind of holiday libation do you provide, right? And for me, being from New Mexico, there was really only one choice, which is to say a margarita. And you can probably divide the world into two camps. People who believe that a margarita can be made from a mix, right? And then people who realize, no, you really need to use fresh squeezed lime juice, right? So for my first holiday party as a member of the commission, I went off to Costco. I bought like 20 pounds of limes. And I thought, this will only take me an hour to squeeze all these limes. Okay. I had a hand squeezer too, right? And so from your laughter, I can tell you have squeezed limes in your life. And so at 2 in the morning, okay, I'm squeezing my last lime. And for future holiday parties, I used an electric squeezer, so I kind of got around that particular problem.
Well, I'll bet none of your guests ended up with rickets, so maybe that was...
Yeah, there was a lot of vitamin C in that margarita.
All right. Any other confessions here? I'm trying to... I can't suck everybody into this.
Clean living, by the way.
Well, we can.
No, just short memory.
Listen, if I started confessions, it would run way into the cocktail hour. But the California crisis come up a couple of times this afternoon, and I have more regrets about that, I guess I'd say. And part of it was following Dan Fessler's advice. But there's several events that occurred in that 1 month period before I left office, including sitting in Shakespeare Theater watching, Othello or something, and my secretary comes in and says, "The governor's on the phone." And of course, Governor Davis, and this is pre-cell phone, so I'd go out in the lobby and stand there for an hour while he harangued me about FERC's lack of responsiveness and so forth. Shortly after that, he came to Washington with a retinue. We got in a room over at the Treasury building 2 nights in a row with the Secretary of Energy, the Secretary of the Treasury, Ken Lay and a bunch of folks on that side of the aisle, energy marketers, and we tried to figure out what's the solution here. And finally, the governor came up with one, and it was, "We'll sign long-term contracts." And I regret at that point I didn't jump up and say, "You have to be kidding me." The fact that I didn't do that is, we're still living with it.
I think we had a technical difficulty for a second. Your microphone.
I think so.
I heard it.
I'm going to close with one comment just before thanking them on all our behalves. Maybe this sounds unsophisticated or even Pollyannish, but if I were in charge of FERC, I would invite this group of former chairs and other former chairs, Betsy also, in to visit with me periodically, just to, throw some ideas around, get some perspective. I couldn't think of a better group if I felt not isolated as chair, but it's a unique position. And no matter how collegial you are with your colleagues, there's a past to almost everything we do currently and in the future, as you can hear as we went through the timeline, just getting their insight and frankly having a good time visiting with them. So I really want to thank this group. If there's an old adage, if you want something done, ask a busy person. That applied here. They were just great getting ready for this, and we really want to thank them on all our behalves. And on to the cocktails.
Maybe there'll be some margaritas. Before we wrap up, I too want to, on behalf of the association, extend my thanks. Outstanding panel. I think this was the best attended last session at any annual meeting ever. We do have a cocktail reception outside. Before we close, though, I want to extend my personal thanks and a great show, gentlemen, to Stu and Damien and Tom and Norman. The Professional Education Council did an outstanding job, so thank you.